everyone. We are here again with N.S.Iyer sir. Uh, if I have to say, he's one of the legends from labor law. I have been very grateful studying from him about the concepts. And in today's time, a lot of HR managers, a lot of founders in organizations are facing with very typical issues dealing with whether it has to do with layoffs or whether it has to do with furloughs or the wages. A lot of acts which are coming in. Even the government is not very clear. Plus, there's a difference between the state government and the central government in multiple states. The idea of this webinar was to basically bring in someone who is learned and respected in this entire community to really help us in understanding all the issues and the doubts which are there currently in respect to COVID. Now, about myself and my startup. So I'm a 2016 graduate from TISS, and I have my own startup called Heads Up. We keep on doing these webinars. We have got a huge list which is also there. This is our fifth webinar in back-to-back weeks. So it's all because of all the participants who have really graced the occasion, and indeed the speakers. To introduce sir, he really goes back really long, and so after completing his BSc Chemistry in 1976 from SIES College of Arts and Science, he did his LLB Labor Laws from Government College in Mumbai, Government Law GLC Mumbai. After that, he did his master's from MILS, graduated in 1981. He did another diploma in learning and development, or training and development as we say, from ISPD New Delhi. In 1992 is when he started, which a lot of people can really inspire to get almost a 30-year plus journey, if I'm correct, sir, with Asian Paints. And and in 2003 is when he started visiting TISS as a visiting faculty. He is no like a visiting faculty. He's as a normal faculty is supposed to be. He is a part of our entire system and has helped thousands of HR managers today, both in industrial relations, employee relations, and things related to factory HR. So I welcome you on the platform, and it's great having you on the platform, and all those 22 things which I'm absolutely anticipating will be very impactful. Even this webinar and people who will see probably the recordings. I'm very grateful that you are here, sir. Thank you for coming, and you can take the podium.
Yeah, okay.
Thank you.
Yeah, and if it's not audible, let me know.
Absolutely.
Yeah. Okay, baby. So good evening, everybody. Thanks for coming over. It's my honor, privilege, and pleasure to be speaking to all of you. I should say that most of the audience today are my students and my professional colleagues, my friends, my family members, etc. So it's very heartwarming to speak about laboring during COVID times. That's the name that I given. So my love and affection to each one of you there. I have been hearing a lot of discussions on this COVID lockdown period regarding wages, regarding leave, regarding recruitment, regarding advance against salary, regarding forced leave. Quite a lot of these things are going on. I've been listening to seminars on this. Some seminar that I have heard, mostly it has been reading up WhatsApp messages, some court judgments, etc. So based on that, then I said, there's quite a lot of confusion, there's a lot of clutter. So I said, to the best ability of, that I know, I'm aware, to the best of my knowledge, I thought that I will share some FAQs. And, if there are more questions to be asked, we'll have some questions also that can be answered by me. So with this short introduction, thank you once again for coming over. I hope this session is useful to all of you. So I would now start the session. Okay. The first question, the first question that is this: during this period of lockdown, is the employee required to pay full wages even if the employee does not report for work? This is the question a lot of people are asking. Now, my answer is very, very clear. As on date, with the circulars from the government, the Ministry of Home Affairs, etc., it is very, very clear, yes, that you will have to pay full wages. Uh, there are provisions of the Disaster Management Act, all of you are aware, which, as per their circular, has the power of overriding the provisions. Some of the provisions that people have been talking about have been of layoff, whether you can retrench, whether you can lay off, whether you can close the establishment. So layoff and retrenchment as by the Industrial Disputes Act, or the shutting the establishment as per Standing Order 18(1) of the Model Standing Orders Act. So these are some of the things people have been talking about, or if there is some provisions contained in the appointment letter. So whether anything could be done that way. So that was the question. So as on date, there's quite a lot of clutter, but going ahead with some of the answers, you will get some ideas to what possibly could be done and how. So as on date, with the Supreme Court to give its judgment on 12th or 11th, there is a hearing on the 11th. So the government has been asked to place its view, and once that is argued in the court, there is something to come. I don't want to say this way or that way what would happen. Let's all wait with suspense for something good to happen, both for the employer and for the employees. So, or if the directives of the government come before that or after that, so we are waiting for that. So, as on date, yes, we are required to pay full wages. Clear? Okay. Now I'm going to question number 2. So I'll finish all the questions and the answers from my side, and thereafter, whatever questions you have, you can raise it. Sumit will definitely enable you to speak.
I'll moderate it. Yes.
Yeah. I will be able to answer that. So just an idea, what is layoff? Since we are talking about it, layoff is the refusal, inability, or the failure of an employer to employ workmen because of accumulation of stock, shortage of coal, or power or raw materials. And there is also one thing which is the most important thing: due to natural calamity or any other connected reason. So the question is COVID, is this coronavirus 19 causing natural calamity? Okay, is it an epidemic? So these are the questions that have been asked. Without getting into too much of semantics, etc., I would myself very clearly say yes, it is a natural calamity because it is not under our control. We are not able to manage that. Nobody is able to manage that. The whole world has been seized by it. So it is a natural calamity, and that is how the provisions of the Disaster Management Act are being applied. Yeah. So this was more as a refresher. What is layoff? So then the next question is, then what is retrenchment? Okay, retrenchment means the termination of the services of an employer for any reason whatsoever, except inflicted by way of disciplinary action. That is, if you conduct an inquiry and dismiss somebody, that is not retrenchment. Okay, and there are 4 exceptions as on date. The 4 exceptions are that if it is voluntary retirement of service, VRS, then that is not retrenchment. If it is retirement on reaching the age of superannuation, that is not a retrenchment. If it is by way of expiry of a contract with a stipulated day, that somebody is on probation 6 months, somebody is on training 1 year, at the end of it, if you terminate, that is not retrenchment. And the 4th is termination of the services on the grounds of ill health. So this is just to give you an idea, set a context. These are some of the issues that have been discussed earlier, but some of the other people have come to grips to accept the fact that now it is more or less that we have to pay full wages. But the question that really comes up is, are small scale industries or medium scale industries are they able to sustain paying these wages? People have made it in March because this lockdown came from 24th. Some people have worked up to 23rd. So to that extent, payable, because there was also money coming in, money going out. So there was quite a lot of cash flow. So it was possible. The complete April is gone. So the employers are talking about as to where is the cash flow. The employees are talking about where's my ration, where do I get food from, how do I sustain my family. There are migrant workers who are suffering. So quite a lot of these are points of agony, right? In whichever category it is, but these are points that are painful. And somehow the other, I am not at all saying that the government is not doing anything or anybody. Government is also grappling with what to do, etc. Because there are several sections that are giving their idea. They're the trade union, they're the employers association, they're the workers themselves, and there is a government body which is also debating all this. I hope something would come in soon. But apart from that, now we have also in Maharashtra, if you go to see, and in many of the places where it is red zone and orange zone, etc., quite a lot of companies are in the contaminated zone or the red zone that you call it. And hence the lockout has been extended, lockdown has been extended up to 18th of March. So the employers thing is that now it is all over till 18th March, May we can't do much, right? So the whole of May is gone. So what do we do for May, even if we are ready to pay for April? So these are some of the questions that have been coming for. And with this context setting, I would get into some more questions. And so first is, can reduction in salaries, or one is reduction in salaries, one is deduction from salaries. So one is reduction, another is deduction. Whether they are allowed, yes. PF and ESI are allowable deductions. That is what at least the government has been firm. They have left the other things a little, but then, statutory compliance, we have to do it. So PF and ESI are deductible. That is what they're saying. Is there reduction possible? No. So they are saying that you pay full wages. So this is something that quite agonizing for the employers. There are no answers straightforward. Senior lawyers have been talking about it. There are videos on that, but arguments both ways. But the Supreme Court, when it first heard it, listened to it and said that we don't want to give an interim relief now. So they have postponed it by 2 weeks, which ends on May 11th. So that is what it is. Just to reiterate once again, there are also some questions like, if suppose we pay advance against salary, okay? If we pay advance against salary, it is advance against salary or wages. Is that possible? I have been advising people that it is possible as long as it is advanced in 1 month or something like that. You can't say till the coronavirus lasts or the lockdown lasts, I will pay advance and wages. Then the next question is, then where is my wage? You are only giving me advance, where is my wage? This is something that we need to understand in the context of law also. In the context of law, it is also that if you are going to give advance, you are changing the conditions of service, which is the fourth schedule of the Industrial Disputes Act. So then you have to give us notice of change under section 9A. So hence, this advance in wages is possible in a month, and that too with the consent of both the management and the employees. And if there are unions existing, then with the consent of the union in writing. Only then there is possibly a defense, and that too for a month. I don't think if you regularly do it, the government will see things behind it. But if there is consent to that extent, you can pay advance against wages. Now, what is this advance against wages? It is about that the company's cash flow is adversely affected. They are not able to pay, and there has to be substantial evidence, documentation saying that yes, cash flow is a problem. If that is not done, then it can be an understanding, and somewhere there is probably some sort of a subterfuge, or there could be some sort of a forcing or a coercion that is done, and that is why employees are affected. The employees have agreed. Now, even if one employee complains against all this, then you have a problem. So the question is, consent has to be total, and yes, advance against salary if true consent is possible, not on a continuous basis, but when there is a difficulty to pay. So probably I am hoping, and if nothing materializes positively, then I am sure it is difficult for most of the employers to sustain, and these questions will start coming now. It in April itself has started coming, so I wanted to touch base on this, and this is my answer as far as advance in wages is concerned. So in advance in wages, you will have to pay PF and ESI contributions, yes. And if you are paying 50% or 70% in advance in wages, the other 30% or 50% that remains, you may have to give a date saying that by another 1 month I would pay or something, just to tide over this cash flow problem. And at that time, the rest of the ESI and PF contributions will have to be paid. But that time, when you pay the ESI contributions, delayed payment will call for penalty, damages, and interest. So that has to be kept in mind by the HR folks who are here. And so that is one of the things that is very, very important to understand. Otherwise, you can pay advance in wages now and then pay the full ESI PF contributions if you want to escape from the penalty, damages, etc. So this is something that I wanted to say. So Section 9 is important, notice of change is important, but if there is a consent, you can tide over it. Otherwise, the union can call it, or the employees can complain it as an unfair labor practice. Okay, so this is something that we have to keep in mind. Okay, so the next question is, can wages payable to employees be deferred, or an advance payment against be allowed? Yes, I think I have answered it in the earlier thing, so I might not go question by question. Yes, I have answered it. It can be deferred. Okay, deferred in the sense that you say that, I'm paying advance, and the full thing from next month onwards I start paying full wages and also the remaining advance, etc. So to that extent, yes, it can be deferred, but it cannot be something that you go on paying it as advance. Okay. So can operations be shut down? These are questions asked by employers who have started operations like the essential services, etc. So these are the questions that they are asking as to whether operations can be shut down if it is found that some employees who have joined, they are afflicted with COVID. Okay. So the answer is here, it is quite straightforward. The entire operations of the factory will not be shut down, right? So there the government is quite clear. However, the section and department where such afflicted employee worked, that part can be quarantined. So this is a very clear and straight answer. So employers need not worry, because everything is not in their hands. But there has to be definitely all the safety distancing measures, the measures that when you enter the factory, there need to be a temperature measure mechanism. Whatever safety measures are to be there, and distancing measures, social distancing measures are there, that has to be applied and implemented to a T. Then the next question is about, can allowances like conveyance allowance, food allowance, washing allowance be deducted from wages? Now, what is the rationale behind asking such a question? Some of the employers and my professional friends have been discussing about it. They are saying that the employee does not come to work, so why should we pay conveyance allowance? Employee does not come and eat in the factory, so why food allowance should be paid? He does not use the uniform, so why washing allowance should be paid? So can it not be deducted and paid to them? The answer is something like this. The Bombay High Court recently has given a judgment saying that allowances like conveyance allowance, food allowance, and washing allowance can be deducted, right? But there is no qualification, with a lot of respect to the Bombay High Court, there is no qualification as to how this is being allowed, but there are several Supreme Court and High Court judgments in this matter which clearly say that, okay, if conveyance allowance, food allowance, and washing allowance are being paid to an employee when he is on leave. Suppose an employee goes on a privilege leave and if all this being paid, then why would you not pay it during this lockdown time? Because when he is on leave, he does not have conveyance allowance, food allowance, or washing allowance. But at that point of time, you are paying. If such is the case, you can't deduct it during lockdown time. Now, there are several cases on this, and it's very interesting read for all of you if you go to the net and see. Now, the question is that there are companies, my own clients who are there, they have clearly stated in their rules and regulations or in a settlement signed with the union that conveyance, food allowance, and washing allowance or any other specific allowance will not be allowed. Okay, if somebody is going on leave or if there is a um, um, uh, you know a thing like any eventuality that happens where salaries have to be paid, etc. So they have very clearly stated that. Whereas the companies have also said that I will pay for house rent allowance and education allowance and not deduct it, because house rent he has to have if he has to lead a life. Education for his children does not stop because he is on leave or something like that. So there has to be specific clauses in the settlements to ensure that. Otherwise, as on date, as I read it, though the Bombay High Court has said it, and the Supreme Court probably, and it has said that we don't want to comment further because the matter is sub judice before the Supreme Court. So the Bombay High Court has left it at that. It's a short judgment, but let us not read it only in letter, but I think we need to read in spirit too, and understand that there are certain qualifications where you can deduct conveyance allowance, food allowance, and washing allowance. Yeah. Okay. Now, by dealing with contractors, is termination of the contract allowable? Okay. Now, yes, and I have a clear answer to that, to the extent that it is possible to terminate the contract. Okay, not on non-performance or something like that, but by there are force majeure clauses, that is acts of God clauses. You can use that and terminate the settlement. Okay, but the question that the courts are talking about and the government is talking about is about what will happen to those employees, right? So in such a case, if that needs to be done, though legally it is possible, today the government does not accept it in spirit. The government will come and give you a show cause notice, and those questions are going to happen. So unless it is really necessary, unless there is a fraud committed by the contractor, unless you can prove that he has not stuck to the clauses of the settlement which you have signed with him, it has become nearly impossible to say. But legally, if you go to see, yes, there is a 3 months notice or a 1 month's notice, you can serve that, and with evidence why you did it, you can actually terminate it. But evidence here during such lockdown things should be that he has committed some fraud, or you are using the force majeure clause. Because I have seen in two companies who discussed with me and with a couple of my friends, was the contractor is terminated. In that case, what do? The contractor says, you pay me my dues and I want to go because I can't survive anymore, because I don't know how it will be possible for it to sustain. So only looking it from the employee's point of view may not be right. So there are contractors also who are terminating, and the employer is also stuck as to know, what do I do for the contract, right? Like there are employers whom I know are talking about, my vendors don't pay me. Suppose I am working in I am doing some service, okay, a logistic service or catering service or something. My vendors are not paying me, so how do I pay? So these are questions that are hitting at the heart of the problem. And I would certainly say that the government needs to look at all this, but as on date, everybody is quiet, and it is leading to more and more confusion. And I think in May or around, I think these matters will have to be supported by some directives of the government. So legally, termination possible, but Government will intervene, who could ask you 1,000 questions. And I am also being told that the collectors in many areas are, visiting, talking to employees, contractors about what is happening. I think that's a good job being done, because there are unscrupulous employers, there are employers who might want to subvert the law, etc. But at the same time, I think understanding the difficulties of both the workmen and the unions and the management is necessary. But there is quite a stoic silence, and unless it is addressed, I think there would be a lot more problems for everybody. I can tell you, it's a fact that a lot of medium scale and small scale industries are actually at the point of God knows what to do type of a thing, and it is severely affecting them. So this is something that has been happening. Okay. uh, there is also these export companies, which couple of them talk to me, and there is no export. There are, because of trade restrictions between two countries, etc. So in these cases also, what is the remedy? There is now, nobody has been looking at it, or I would say that the government is grappling. I am sure that the government wants to do something, and it would come out with some guidelines. But the issue is, as on date, if you ask me a blank question, I would say carte blank, you will have to, you are required to pay. It's unfortunate, but yeah, that is the way things are going on. So now the next question is, how long will the employer have to continue to pay wages even if the workmen do not report to work? Yes. So I'm going to my first question and answer, where I'm talking about, yes, as on date, the Supreme Court and the High Courts, etc., have been talking about it. No relief has been provided, neither the government. Okay. So yeah, as I said again, this question is being again answered the same way, saying on 11th May, let us see, keeping our fingers crossed, that is what is going to happen. So there is quite a lot of uncertainty now. So I have answered quite a lot of questions, but I keep on wondering when I talk to you as to, so what is really coming out? What is really coming out and what is really hitting the eyeballs is, yeah, as on date, yes, there are very few options left for the employer but to pay wages, right? Okay. The next question is about, if employees are engaged in piece rate or fixed on tonnages, is wages payable? Okay, because the employers say that he produces so many, I pay. He produces so many tons of so and so, I pay. Now there is no production. Okay, how do I pay? Should I pay? The question from the employee side is, I am ready to come to work. Okay, I am ready to, but there is a containment zone. Okay, there is my village where I am ready to come, but my villagers, my people staying around me tell, if you go, don't come back here. Okay. And there is quite a lot of other things, like, do all employers provide transport? Okay. Do all employers assure social distancing? So these are the worries of the family members. Do all employers ensure safety? So these are some of the things that are hitting hard. So my answer to this question is, and this has been discussed with some senior people also, and senior lawyers at that, they are saying that even in such cases, you have to pay the average of the last 3 months, whatever they have produced. And this is somewhere very, very hard to accept, because for an employer, because there is no production, there is nothing that is happening. But my view is that you probably could talk to them, talk to the contractors. Okay, make them understand that there is no production. Okay, there is something severe crisis that the company is facing, and that too with records and documentation. Explain to them, and as I said earlier, try to get the consent and probably pay minimum wages. I am saying this at the risk that I may be wrong, but I am also saying it looking at from the point of view that you need to be practical. The employees need to receive wages. Okay, employees also, in many places that I have seen, are asking that give us something, don't say that I will not give you, because they also understand that they are engaged in piece rate or on tonnage basis, etc. So I think the employer needs to be fair, okay, because this is not the fault of the employee too. And hence from that point of view, I would say, why I say minimum wages, I am talking about minimum wages more from the point of view of that is something stipulated by the government, and I am agreeing with my employees or the unions to say that, okay, we both have understood the severity and the disability and the sustainability in the future of the employer, and which is also which uh, also will adversely affect me in the future, an employee could say, and hence we have agreed. So these consent things have to be clear, and once this is accepted by both the parties, then it is still possible, like an advance against salary. This also could be possible, but there are some senior, heard one of the seminars where a very senior eminent lawyer of the Supreme Court said that 3 months average wages has to be taken of the last 3 months and has to be paid for, even for piece rate or fixed tonnage employees. So this is what is it as on date. Okay. The and in this, I think you need to have very clear supporting evidence of your financial unviability, etc. Because when you are, nothing may happen now, or if you don't do it, but there would also be, a PF authority who would question why did you pay lesser wages, or ESI authority would question, a government inspector would come and check later on, and there could be a show cause notice, etc., which could come. At that point of time, we need to have enough evidence saying that during April, during May, our cash flow and everything was absolutely bad. It was just nigh impossible for us to pay. So these are something safeguards, but they needs to be maintained. Documentation is necessary, right? Okay. So the next question is that if the training periods ends during this period of lockdown, can it be terminated? Certainly, there is nothing wrong, because the employer, when he appointed an employee, did not know that at 1 year later there would be COVID around this time. So it can be terminated, but whatever dues, whatever needs to be done, can be done. And I think there are some affirmative answers we need to have. And if challenged in a court of law by somebody saying that it was during COVID, etc., you have ample evidence to show that what you did was right. So for me, it's an affirmative answer. Similarly, can the training period or the probation period be extended during the period of lockdown? Yes. Suppose somebody was to his training period was getting over by May end or May 15th or whatever, and if he has not been working from March 22nd or for about 1.5 months, I am of the view that the employer can definitely extend it by 1.5 months or 2 months, as the case may be, till the lockdown opens, and he can extend that employee's training period or probation by the period during which the employee did not work, because it's about a training, it's about a probation, it's not about he was ready, the employer was investing in him during this period of time of training, etc. And hence the employer, even if it is training or probation period, has the right to extend the period of probation or training period by the time that because of lockdown or something, that he did not work and they did not get training, right? Okay. Can an employee be terminated during probation? For non-performance. That is why this is another specific question. Yes, but you will have to have that it cannot be during the, and this is specifically asked by somebody who is working from home. So these are several questions asked. So if I'm working on, if my employee is working from home and he is not performing well, etc., can I terminate? See, it cannot be non-performing during the COVID period, because there are stressors, there are quite a lot of things that does not happen. There is no personal attention for the employee, etc. But if you see for the last 6 months, it has been bad again, and there is continuous non-performance. You have enough data to prove that there is non-performance. Then definitely you have the right to terminate. But here I would put a caveat. Can't you wait a little longer? Okay. can't you the question by the employer is, it's not about waiting longer, but I have to pay for his non-performance because he is not performing and still have to pay wages, the full wages, etc. So my reply to the employers has been, hold on, let us see that, and there are one or two people who have asked this, but I've raised it up because several people may have these questions in mind. But let us see as to what happens. The government definitely has to do something in May. Hopeful, okay. And with this, but if you ask for a straight answer, yes, they can be terminated during probation or training because of non-performance. But non-performance is something has to be proved, and it cannot be said that I have an appointment letter which says that I can give him a termination by giving 1 month notice or 3 months notice, and I'll use that clause and making it look like a simple termination or something. No, a lot of things will be right behind that, and hence whenever it is non-performance, you will have to prove non-performance. Okay. Can employees be forced to go on leave? No. Why? Because it is more from the point of view that when an employee goes on leave, he applies for leave and the leave is sanctioned. So there is no question of the employee being forced to go on leave. Again, so because what the employers are saying is that suppose this lockdown goes up to June or July, etc., they are saying our calendar year for leave is from January to December. And if you are going to start in July, or even if I start in June, time it picks up and I get first 33% employees will be allowed, 50% will be allowed, 100% will be allowed. There might be, actually we might start in July or something like that. And thereafter, if an employee applies for leave, I will not be able to give him leave, right? And today, if there are employees who want to go on leave, okay, I let them go on leave and I'm ready to give them leave. This is what the employers say. But the employers say, if tomorrow I don't sanction him leave after July, and if his leave lapses, then at that point of time, I can't do anything about it. So employers of the view, several employers, as to why that, can I ask people to go on leave? Here again, I talk about consent. Because I have seen in all the answers the advance against wages or deductions or all that, if there is a consent and if there is a willingness, because there is an element of sacrifice from the employee, and if there is an element of sacrifice, the employee and the employer, out of free will and volition, voluntarily agree to something, okay, there could still be some way out. Now, is it legally correct? Is it against the law, etc.? The government could interpret it in any way, and we should be ready for that. But why are we doing all this? Is to ensure the employees don't suffer. And if the employees are ready, and some of them are ready to go on leave, though they might ask that if I apply for leave, what do? I can't go for a vacation. I can't go anywhere. I can't even go for a movie or a mall. So what do? These are questions are there, but the employers say clearly when they're talking to them that if there is leave that is going to be surplus, then at that point of time we may not be able to give them leave. So this is where the position is as on date. If an employee has tendered his resignation and is on notice period during lockout, can he revoke it before the last date of termination? Yeah. Now I would actually take you to generally what was the law. The law earlier was that if an employee applied for leave, yes, if an employee applied for leave, tendered his resignation, and he had the right, okay, he had the right to revoke his resignation even one day or on the last day of his resignation. So that was the law, and there were several so there were several contentions, etc. But recently, in August, I think, yes, in August 2019, if I am not mistaken, the Supreme Court in Air India Express Limited versus Captain G.K. Sandhu has said very clearly, and these are things that is important for y'all even to change in your appointment letters. So what it says is the presence of a provision to the contrary in the contract of employments and service rules. Suppose you are saying that an employee cannot revoke his resignation. Okay, if you put that clause in the appointment letter and say that is because when an employee has resigned 2 months notice or 3 months notice or 1 month notice, the case may be, and if the employer has already got a replacement for that employee, then the Supreme Court has very clearly said that if the replacement is already ready to join at that point of time, or will join after the last day, at that point of time, because I have already taken the cost of the replacement, the employee cannot revoke it, but you have to have this in your appointment letter. So my thing is, please read the judgment of it is just the last year, August 2019, and ensure that a clause is inserted either in your service rules or in your certified standing orders or in your contract of employment, and ensure that such cases are minimized. Okay, employee, because employee is already gone, he's going to do his work on his service notice period, and at that point of time, if he revokes it and you have already got somebody on the job, then it is not fair for the employer. So the Supreme Court, in its wisdom, and I appreciate that, because generally people have always been saying that quite a lot of things are happening, looking at the labor, etc. But I think this is a tremendous step that the Supreme Court has taken with respect to ensuring at least two clauses have been put, and these clauses are clauses where the employee may not be able to revoke his resignation.
It's been almost 90 minutes of very, very enriching experience, and we have had a lot of participants both here on YouTube as well. And for the people who have probably missed it, there will always be a recording, so people can go have a look on that. And also to all the attendees, there would be a PDF which would be circulated very soon after this webinar, which will be carrying all the answers which Sir has given during the course of the webinar. And so anything else you would like to say to all the attendees?
I would like to say there were a lot of questions probably on the chats which we couldn't take, or there are questions that people had in their minds could not answer. So what I would tell them is that my email ID is IYER. You know it, Sumit. Okay, yes. So you can flash it on the screen, or I could flash it on the screen. Anyway, people can hear me out. IYERSUBBA IYERSubba@gmail.com, and I am ready to answer those questions. And probably some of those questions I will use it in my next seminar too. Because there are very different situations, typical situations, atypical situations that people face. So I am definitely ready to answer all those questions. If it has to be a private chat, I am ready to do that. My mobile number is available. So I am quite open in answering, because these are difficult times, and probably we also have to come with creative solutions to quite a lot of these things. It's not about legal. Legal, everybody knows there are enough lawyers who will advise. But then there's
Sorry, so there was a tech glitch. Sorry for that.
Okay, yeah.
Okay, so I think on that note, we don't have any further questions, and I've flashed the email IDs also. So yeah, so I flashed the email ID also, which is there in the chat, so people can reach out to you directly.
Yeah.
And fair enough. So thank you for coming.
Thanks a lot.
Enlightening a lot of people, and we really hope that you had a good time. And the video will soon be up, so that a lot more people can see this thing. And thank you for this. Thank you, sir.
Thank you so much. In fact, thank you for the opportunity. I should thank you, Sumit, and the company that you're in, Heads Up Corporation. So heads up to your Heads Up Corporation, and do well. And thank for all the participants, quite a lot of them who have stayed till the last, so I am very thankful. And for me it was again an experience, because I think this is the way life is going to be.
Right.
So thanks a lot, and wish you all the very best. Stay safe, stay fine, and my love and affection to all of you.
Thank you, sir.
Thank you so much.
Thank
Yeah,
you.
yeah.
Thank you,
Thank you.
everyone. Have a good night. Until the next webinar, which will be soon up. Thank you for joining me. Thank you.
Thank you so much.
Thank you.